So there is a planning opportunity that doesn't require moving. There, with the nings, dings, and wings, the ing portion is the incomplete gift non-grantor trust. And they're trusts whose main thrust is to shift the tax liability for earnings from assets to the state where the trust is created, Nevada, Delaware, and Wyoming. Apparently, there's been a resurgence in these type of trusts, primarily because there was some pretty favorable federal public letter rulings that state that it's not a current gift, so that there's no gift tax implications or generation skipping tax implications, but the trusts have to be set up in a very particular way. They can't have a resident, it has to be a non-resident trustee, and distributions are subject to the sole and absolute discretion of the trustee. So for an example, California resident Gavin has a $10 million portfolio with long-term securities that have a cost basis of $1 million. If Gavin sells his entire portfolio to contribute to his latest tax and spend initiatives, he would recognize a $9 million gain taxed at the 20% federal rate, not counting net investment income tax. In addition, with the California top rate at 13.3%, he could owe another $2 million on the $9 million gain. Gavin sets up a ning, ding, or wing with no California resident trustee and transfers the $10 million in assets, and then the assets are sold. Currently, there's no state income tax to worry about. He saves nearly $1.2 million in state income tax, even though he still lives in California and continues to tax the heck out of his California residents. The trust would have no California resident trustees, and no trust income is currently distributed or distributable to Gavin. California income tax would be payable if and when the trust income is ultimately distributed to Gavin, if at such time Gavin is still a California resident, and therefore he escapes taxation completely, at least California tax. I have a couple more comments on stock options.
We have one more speaker. We're running out of time.
Oh, we are?
Yes.
Okay.
Okay, my assignment is businesses. How do you get out of California? Well, if you are, first of all, what constitutes doing business in California for a business entity? Are you formed in California? Are you registered to do business in California? Or there's what they call a bright line test. But basically, if you're actively engaged in any transaction for the purpose of financial or pecuniary gain or profit, you're deemed to do business in California. And that's important because we're all focused on this bright line test, which currently they've only announced it through 18, but 19 it'll be about 600,000 in sales, or the lesser of 60,000 in wages, or real property, or 25% of your total wages or total real property. But bottom line is, so that's a bright line test where they're saying you're absolutely doing business in California. So worldwide companies that end up with more than 600,000 of revenue in California are going to have to file in California, period. That's important because California does something called unitary. It taxes on what they call, basically they tax units. And the units are, we could do 5 years on talking about how do we work with what is a unit and what isn't a unit for and the Big Four have major practices that are focused on unitary tax for multinational companies. But they're basically, it's the 3 unities: unity of ownership, unity of operation, or unity of use. So California will come through, and there's all types of ways they will try to make you unitary, because once they get one of those units, those members of the unit in California, they've now pulled in everybody. My practice is very focused on entertainment. My film production companies, often film production companies, big major motion pictures, they're sold worldwide. You hear one of these blockbusters that is basically half of it's CGI, so it's being made here. So you've already now got a nexus into California because you're actively doing business in California. You have $500 million of revenue worldwide. You're now going to California, sources income to California based on one factor, which is revenue. The good news about that for my production companies that are actually here is that revenue is sourced based on butts and seats. And butts and seats are worldwide. But the bad news is if you used to do business, if you were a production company that was in Germany, say, and you made a blockbuster picture that was a worldwide release, you're now going to be paying tax in California. So it's a very, California is fine. They used to have a 3-factor. It used to be property, payroll, and revenue. And so there were a lot of games you could play if you didn't, and you used to have nexus based on physical presence. So there were a lot of games people could play. When they went to revenue and they went to the bright line, people were, why would you do that? Because they lost revenue. No, they gained worldwide revenue by doing that. And California is going to get more and more aggressive. There was a court case that was a sales tax case, but many of the states, including California, are following the concept, which is the Wayfair case. And that's based on not just revenue, but it's based on transactions. And we're waiting. I mean, we know that California is one step away from not just having a bright line in terms of total revenue, but having a bright line in terms of transactions. That bright line is in some states, in the Wayfair case, it was 100 transactions. 100 transactions at $1 a transaction would cause you to have to file. California had a transaction number for sales tax up until I think Gavin just changed it. He got rid of the transaction. Now it's just revenue, but it was 200 transactions. So if you had 200 transactions in the state, it was going to trigger a sales tax requirement. They're trying to get from that to income tax. So the bottom line is California tried to get really, really aggressive in swart enterprises. Okay, that was basically we had a investor in an LLC that did business in California. California tried to say that investor that was a passive investor, did not participate in management, effectively was similar to a limited partner. California tried to tax them, at least with respect to minimum tax. They were shut down on that score. But what's left open is, what if you are a passive investor and your share of that passive investment reaches the threshold of the bright line? We don't know. We don't know if that's going to bring that passive investor into taxation in California.